08 Fragel and Fragel. We have Ms. Gilmore. Do we have anybody else present on that matter?
I'm here, Your Honor, Marcelo Renee Fragel.
Okay. Ms. Fragel, I did not see any response from you as to any objections.
It's an agreed matter, Your Honor. I just couldn't sign it at the time.
Okay. All right. So with that, so if I understand correct, I seem to get a feedback here. I don't know what's going on. So you're in agreement with the proposed order? Okay.
Yes.
All right. With that, I'll go ahead and sign off. All right. That takes care of that matter.
Thank you, Your Honor.
And then Natasha Tovac is present for Mr. Garcia.
All right. Be just a minute here. All right, I did see the objections. I don't know if the parties have talked about those at all.
Yes, so for the child support order and the temporary family law order, we have come to an agreement on the changes. So that is, we don't need to go over that. I think mainly what we have not come to an agreement on is the parenting plan. And looking
so are you going to get me new orders or what are you going to do?
So I just wanted to have some clarification on specifically the school schedule, Your Honor. It looks like.
Okay, let me back up.
Okay.
Okay, the matters that you're agreeing on, are you going to get me new orders to reflect those changes? Okay, then
yes,
I will not be marking up the ones that I have in front of me. So. All right. With that, go ahead.
Yes. So for the parenting plan, mainly, I think the biggest difference that we have in our parenting time schedules is mainly I would like to request to have specific dates and times for this parenting plan. Mother and father have been trying to work out some days and times to meet at the grandparents' home, and that has been pretty limited. The 2:30 to 4 p.m. is the days and times that the grandparents have said that they would be available. Otherwise, that second visitation would need to either be through Reconnecting Families, and I was just informed that Reconnecting Families is pretty packed, so they're not able to get scheduled parenting time for those days. I would like to propose having Cassandra Wally, who is part of TLC Behavioral Consulting, who does, who does parenting guardianship cases that, will sit in on parenting time, and she can do it in public in Longview if Reconnecting Families is not available.
Mr. Sandy?
Yeah, in simple response to that, the court largely adopted my client's proposed parenting plan. I think the only change you made was to the preschool schedule for this very small child. Again, Gianna's only about 7 months old. This is temporary. This is going to be back for interim review on April 16th. And as the court's well aware, anytime there is supervised visitation, whether that's by third parties or Reconnecting Families or another similar professional supervisor, you are kind of at the mercy of their schedule. So parties have, since we've been in court 2 weeks ago, parties have had visits, those have gone well. Reconnecting Families has availabilities. The problem with that is you can't dictate to them when the visit is going to occur. That's kind of as they're available and as the parties are available. Again, I don't anticipate any problems with that. I think my order that we have provided accurately reflects the order of the court. We ask you to enter that. And as far as this, I wrote her name, I believe the counsel said Cassandra Wally from TLC. Again, that person was not contemplated at the time of the hearing 2 weeks ago, and I don't frankly know who they are. So I do think that given we're going to be back in a month, given the fact that we're subject to the supervisor's availabilities, which again has not been an issue up until this point, I just asked the court to enter my proposed parenting plan that we filed last week along with my objections.
May I reply, Your Honor?
Go ahead.
Mainly, going through this, I was not informed that Reconnecting Families is very busy, so that is why I'm offering a second option. This was not told to me until, an hour before the hearing. I'm trying to ensure that my client has his scheduled parenting time, and with the pattern that mother has either canceled parenting time or has had to reschedule, the day before for, in the past, I think having scheduled parenting time is what is best for both parties. And then additionally, I'd like to point out that Mr. Zandy's parenting plan was a mandatory form in 2016. It has now since been updated in 2022, I believe. So that was the parenting plan that I had utilized.
So in regard to the parenting plan and the time, one is I want dad to have contact. That is not a question. That's why I ordered what I did. And so I want to make sure that's getting done. And I appreciate that third parties have their own schedules, and this is imposing on their schedules. At the same time, if there's someone that's not available, then we need to look at alternatives. And if the one professional place is not available, then we need to look at another. Problem is, I'm not familiar with this individual that you talked about. Is that a guardian ad litem out of Vancouver or something?
Correct. We have used her before, and she did say that she is available to do individual parenting time overseeing for, I don't know if it's specifically those dates that we have proposed, but she did say that she could be available to have parenting time in public in Longview.
So what I'm going to do is, in regard to the parenting plan, again, I adopted the mother's parenting, or what Mr. Zandy had proposed as the parenting plan with the few changes that I talked about. So what I'm going to say is, again, that if the grandparents are not available, then the professional place will do it. And I apologize, I'm going blank on the name of it, but and if they're not available, then this guardian ad litem that's been approved and on a guardian ad litem list, which means they've also had the background checks, can do the visitations in public in Longview. But it has to, that's the hierarchy of whether or not that person's going to do it. So I want these visitations to happen. And if the grandparents can't do it, then those are the two alternatives.
So grandparents, reconnecting families, number 2, and then council, you'll have to send me the name for this third person in an email, please, if you can, and we can include that. I'll put that in the order. We can present that ex parte, hopefully in a day or 2.
Okay.
Fair enough.
Yes. And I just wanted to clarify for the record, Your Honor, I do not believe that Cassandra Wally is a GAL, but she is a family therapist. I will just have to double check. I got a recommendation from one of the other attorneys at my firm that we have used her before. So I just want to correct the record that I don't believe that she's a GAL.
All right. Mr. Zandy, if you find some issue with that person, bring it back and we'll readdress it.
Council, you give me her CV too, please, so I have that.
Yes, I will.
Thank you.
Okay.
Okay.
All right. All right. That takes care of that. So in regard to this hearing here today, there's one purpose and one purpose only, and that is whether or not Mr. Anagnostu's client is going to sign off on the releases to get the records that Ms. Cotto had requested, or whether or not we need a special master. That's the only issue we're here before. This matter has been set over to try to see what could be done. And from what I'm gathering, releases have not been completed to what needs to be provided. So council, I want to make sure that's what we keep this focused on.
Thank you, Your Honor. I did provide Mr. Anagnostu with some releases because my client did the research and found we actually filled them out, sent them to Mr. Anagnostu. I didn't get them till Friday. I did not get them to him till Friday. We've checked with Navy credit union, the Navy Federal Credit Union, they will honor my subpoena to tecum. I may ask for the judge's signature on that, but at this point, they have a Washington branch, so it appears they will. So I'm going to be taking care of that next week as soon as I get back from vacation. The other matters, I haven't received a response and haven't received a signature. I do not have any releases signed.
Mr. Anagnostou?
Yes, Your Honor. The issue is, counsel makes requests in her response to your suggestion about having releases, and says a release of information for Veterans Administration, St. Luke's Hospital, Navy Credit Union. We can agree with those. Then in the body of her affirmation of counsel, she asks for all sorts of other information, including they are now apparently asking for the petitioner's social media accounts. I want the court to ask counsel, because she and I had a conversation about social media accounts where we agreed we weren't going to provide that information. If we're now going to provide that, then you know, we have issues with that. He hasn't responded to the discovery as well. So we don't have an issue signing releases for the Veterans Administration, St. Luke's, and Navy Federal Credit Union. It's when counsel goes beyond that and asks for releases for counseling, mental health, the social media accounts, and that we've agreed not to turn over. So that's the issue that we have today. And I received this response basically late yesterday. My understanding is Your Honor suggested that we do releases and wanted input from that. We were able to give input not until Friday last week. And then I wasn't expecting a deluge of documents from counsel today. So, potentially the court could set this matter over so we can clarify what the issue is, but we don't have a problem doing releases for the Veterans, St. Luke's, and Navy Federal Credit Union, which was the request.
Your Honor, we did specifically request in our discovery, we asked for counseling records, counseling information, mental health information, psychiatric information. That was what we put on the VA release. We know that there's mention of other counseling records. It was specifically requested. We don't know the name of that person, so I wasn't able to get a release from that person because it's not been disclosed. So as far as the social media account, I'm not complaining about this at that point in time. Mr. Anagnostou and I can have a conversation about that later. What I'm really interested in is the full disclosure of all of the veterans and St. Luke's, including counseling records. We asked for all this.
So it sounds like 2 releases, full releases. Is that what I'm hearing?
Yes, and we are. I will actually send a second discovery request asking for the name of that counselor, so then I can do separate. But that's clearly not. We did not know who that person was.
So, Mr. Anagnostou, it sounds like the request included counseling records from those 2 specific places. So, are you saying that she will not sign releases on the counseling records?
We released and have no issue with regards to the VA documents that discuss her counseling records. The actual individual notes that the counselor takes are a separate issue that counsel is now asking for. We've released the information that she has counseling and she attends those, but they want the actual personal notes that the counselor makes during sessions. Those are protected. And there's cases where and I can provide a briefing on this if Your Honor wants it, where the court will do an in-camera inspection of those to see if they should be released to the other side. And so if that's the request, then it's from our point of view, it's a new request because we've released Veterans Administration documents and St. Luke's documents. And it's contained in her affirmation. It's not contained in the motion part of it. Then we'll bring a motion for a protective order so that the court can determine whether we're going to do this in camera with regards to those personal counseling notes or have some other relief.
Your Honor, I guess at this time I'm objecting. This is the ongoing issue with Mr. Anagnostou. He argues something not before the court that I'm hearing for the first time. It's not in writing. If I I had submitted my discovery request. It included counseling records. Now he's trying to limit. If this is a motion for limitation, was my complaint. That's why I provided a written response. We have not received a single release. He claims I've gotten it. I've never seen it. She signed a release to get the documents to provide to the court in the discovery, but it does not have my name on it. And so if counsel's making all these new requests, he's got to follow the rules. CR 26I is very clear, and he's trying to limit.
All right. I made it very clear last week that if the parties did not have the releases, did not have the information that they needed, that I would be appointing a special master. That's going to occur. It is a special master that you had agreed upon and who would do it. The cost of it for now will be split 50-50, that the final amount will be reserved for the time of trial or earlier if need be. But for now, I want it 50-50. I can't tell because I'm not looking at anything to see what was requested. I'm not looking at anything at what they've signed off. I'm not blaming anybody at this point. I just want this to move forward. It's not moving forward. We've had hearing after hearing and not getting anywhere. And so again, at this point, it'll be 50-50. That does not mean, Ms. Cotto, that at some point that it won't be required that Mr. Anagnosti's client is required to reimburse that full amount.
Your Honor, could I ask one clarification? Last time we were before the court, you indicated that Ms. Hoffman was going to pay the majority of it, if not all. Is the court changing its position on that? Because my client makes a lot less money. We're here because I can't get information.
I understand that. Can you hold on just a minute?
And can I ask for a clarification, Your Honor?
Go ahead.
The discovery master will be with regards to discovery issues both ways.
No, Your Honor, I'm objecting. We are not before the court in regards to my client's discovery.
I understand, Ms. Cotto. Right now, Mr. Anagnostou, this is limited to just your client's records and what had been requested by Ms. Cotto. I know that you are now bringing up additional issues, but that is not before the court, and the court will not consider it. All right, so here's what I'm going to do. At this point, I'm going to revise what I stated. If I understand correctly, it looks like it's 60-40 for incomes. Wait a sec. Never mind, strike that. I'm looking for the actual order of child support.
That has changed significantly, Your Honor, because my client is now retired from the Navy or the Marine Corps. So I can get the court. It's been filed. It's just, I don't know exactly where it was filed, but we filed income information some time ago. I don't know exactly where it was because there was a motion to change child support. We filed a response. The court denied that request of Ms. Hoffman, and there's income information contained in the record. I just don't know exactly where it is. My client's income is about $3,500 a month, I think, off the top of my head. And I can look, but.
Mr. Anagnostou, about what is your client's?
Off the top of my head, Your Honor, I don't know. I would have to look for that same document.
What I would suggest to the court is I can ship over my client's income information year to date or last year's W-2. I would ask for Ms. Hoffman to do the same because she works a lot of overtime, which definitely affects her bottom line of her income.
So the child support worksheet I'm looking at has Caitlin at about 4,300 net and Corey at about 2,900 net.
There's a dispute on that, Your Honor, because that's Mr. Anagnostou's worksheets. If you look at mine, there's a different number.
Okay.
We didn't agree on the income. We can't agree on it.
So get me some information. I will split it in accordance with their incomes, and I would agree. So I'm revising what I said earlier. I agree that this should be split a little more. Again, this is not a final number. This is just to get this moving forward.
Okay, so I can do an order. I'm on vacation next week, so I won't get it done, but I can do an order accordingly. And we probably will have to have you review the incomes because clearly Mr. Anagnosto and I can't agree on a single thing. And I can note this up in 2 weeks. We can come back with income information, but I need specific dates to get, because we've got to get this going.
Yes, yes, you do.
So 2 weeks for income, because I don't think Mr. Anagnosto is going to agree with my numbers. And then in the meantime, I would ask that the court order the parties to get a hold of the special master, see what type of advance fee she requires, and actually see what we can get going in 2 weeks.
Mr. Anagnosto, anything further?
The only thing is we've already provided my client's W-2 as part of discovery, so we have that information. I don't know that we have Mr. Hoffman's income information.
But I need it. I'm looking for it.
I understand. It's just that I just want to let the court know that we have my client's W-2.
Okay, just ship me the W-2. Each of you ship me the W-2, and then I'll know what their incomes are.
Okay, so do you want to review in 2 weeks or not?
Just send me an order with blanks and I'll fill in the percentages.
Okay. I won't get to it till next week, but I will get it done.
That's fine.
And then just making sure that the parties get in with the special master as soon as possible.
Okay, and just do a cover letter that reminds me so I when I see it or my staff sees it, they know what it's about.
Okay. Understand.
All right, that takes care of that matter.
Thank you.
All right, I have Ms. Bliss here, Mr. Anagnosto. I did not see any objections filed.
Your Honor, I received an order from Mr. Anagnosto on Friday. I got him some proposed revisions yesterday, all of which, well, all but one were agreed upon. So I don't know if the order you have is from Friday or the most recent one from yesterday.
I do not see an order
Okay.
in my file.
Then that's probably why. So there's only one point of clarification that I'm requesting at this point, and then I'm imagining we can get an agreed order over to Your Honor today. In this matter, you entered spousal support in the amount of $1,200 to be paid from my client to Mrs. Edmondson. In your ruling, you indicated if she were to obtain employment, there would essentially be a dollar-for-dollar reduction as to his spousal support. Mr. Anagnosto has agreed to include language to that effect. The only point of contention, at least from my understanding, is I'm requesting language that requires Ms. Edmondson to actively seek employment. I think based on your ruling for that dollar-for-dollar reduction, it's the court's intention that she's to seek employment. I think that's a natural occurrence with these matters. So I'm just asking for language to be included that indicates that she is to actively seek employment.
Mr. Anagnosto?
I agreed with counsel's requested changes with the exception of that request. That just sets up the case for issues in the future that the court did not order. My client, she's in her 60s. She's going to seek employment. She needs a vehicle first, and that's part of your Honor's order. She can't even go to job interviews or a job at this point without a vehicle. So we didn't discuss this. It wasn't part of your ruling. And so I'm requesting that the court not indicate that my client has to, because that just sets it up for future litigation. Those are my objections.
And Your Honor, you ordered transitory maintenance for a period of 6 months. I believe it was your intention, obviously not putting words into your mouth, but based on your ruling, it was my understanding that your intentions were for her to seek employment. So I think giving her this transitory maintenance and not requiring her to actively seek employment, I think we're going to be in the same position in 6 months from now that we are now, and she's going to make a request for additional support without actively seeking to remedy her financial status.
So part of the reason I set it at 6 months is to basically motivate her to look for employment. That was the whole point behind it. The problem is that I have with adding that and she needs to pursue employment is that what is she supposed to turn in, proof of 3 times a week or what? So that's the issue that I have. The only thing I can think of that I would maybe consider is to, at the 6 month point, add something that says the court will consider or whether or not she pursued any kind of employment during the past 6 months, something of that nature. So it's not necessarily saying she needs to pursue it, but it's a factor that would be considered in 6 months if she comes back to extend it. So the whole idea is she needs to go look for work.
Agreed.
Very good. With that, I can get those signatures over to Mr. Anagnostou today, and those can be entered ex parte.
Okay.
Thank you.
Thank you.
Yes, Your Honor. Beth Fellows, GAL, is present. Unfortunately, I'm having computer issues, so my camera is not on.
I apologize. Who just spoke?
Beth Fellows, the GAL.
Oh, okay. Thank you. Mr. Zandy, are you there?
He might be in Wakayakum, Your Honor. He's been toggling back and forth. Since he's not on here, I think we probably need to just perhaps come back to it after your next case,
Okay.
if that's okay.
All right, we'll take that up in a bit here.
Thank you.
Cheyenne Acevedo present, Your Honor.
Corinne Ignacio on behalf of petitioner Christopher Crocker.
Twyla Corey, guardian ad litem.
So one of the things that I want to address is just right before court, I was handed a declaration from Christopher Crocker, and it contained within it an immediate restraining order. Ms. Acevedo, did you receive that?
Yes, Your Honor, and I did receive that via email. The grounds for that is
Okay, I just want to make sure you received it.
yes, I did, Your Honor.
Okay, so Mr.
Your Honor, that was emailed out only yesterday.
Right.
Right. That's why I honestly have not been able to even read it. It's an ex parte request, it looks like, and a bench copy. So I haven't looked at it. I haven't looked at the motion. So at this point, I'm not considering it. That's something that can go through the ex parte process, Mr. Anagnostou, if that's what you want to do.
Yes, that's what we want to do, Your Honor. But we didn't want to do that process without you being aware of it, given that this hearing was set here for today.
Certainly. Sure. No, I appreciate that. I just want to make you aware. I read the declaration. It's about as far as I got.
Sure. No, I appreciate that.
All right.
So with regards to today, I want to point out to the court that we were on docket last week in front of Commissioner Warning. And Commissioner Warning indicated that he wanted both parties to do drug testing again. And Ms. Acevedo objected to that and said that, anyway, Judge Warning made it absolutely clear that she needed to have drug testing last week. So we got the results of that drug testing only on Friday. And she is positive for alcohol and for cannabis. And these are complaints that my client has been including in declarations that she has a drug and alcohol issue, marijuana and cannabis issue. And then there's declarations about her doing, cocaine in the bathroom and various other things. And so we have repeatedly asked that she have a full evaluation with input from my client. And an evaluator should be given this kind of information. And get into any recommended treatment. And to date, the court hasn't issued an order to that effect. What the court's ordered is several times that the parties participate in both hair and UA analysis. My client has done all of those, and they're all clean. So here we are. She objected, we think, last week to having it, because apparently she didn't have the kids and she was out partying. She's young, she's in her 20s. And my client has repeatedly pointed out since September of last year that he was the primary parent. He has always been the primary parent. She has never responded to that. There's been no response or no objection that my client wasn't the primary parent. We have this incident where my client was charged criminally with reckless endangerment. What was happening was she took the children from him. She, at one point in time, had a relationship with a registered sex offender.
Hold on. FTR just stopped. Agnostic, go ahead.
She had entered a relationship with a registered sex offender. My client went to her father's home where she's residing and tried to retrieve the children, and he got criminal charges against him. And he has paid the price for that. He had primary residential placement. She's in this negative relationship, denying him the children. They've always resided with my client. He's paid a heavy, heavy price. The court went from him having primary residential placement to this split arrangement. And then we get the guardian ad litem report, and it doesn't take into consideration, from our point of view, any of the evidence that he submitted. And now this new evidence that she's positive for alcohol and marijuana use when the court requires her to do a UA and hair follicle test, the same day. So we're asking that the court not make any changes to the temporary order. The temporary order, has cut him down to half-time with the children. He had full-time. He's paid a heavy price, but he's gone through the criminal charges. He's done whatever basically the government's required of him with that regard. It was a one-time incident where he was trying to protect his children that ended up going awry. That happens in occasions. He has no other criminal history. He's repeatedly taken UA and drug tests. He's in counseling. He's indicated the treatment that he's gotten and maintained for his sobriety purposes. So at this point, we're asking that the parenting plan or the residential arrangement stay this as is, and that we, set this up for a trial so the court can listen to the witnesses, take this evidence, look at or hear witnesses testify. And in the interim, we do need her to get into or have an evaluation, a full evaluation with input from my client and taking into consideration the results of these drug tests. So that's our request today, that the court leave the visitation as currently set, and that the court do grant his right to, or the requirement that she have a full evaluation with input from my client.
Acevedo?
Yes, Your Honor. Last week when Warning asked for our drug tests, I did not object. I did request that I could do it the following day because it did conflict with a medical appointment. He let me know that was not an option, and I had my UA tested and everything done by 11 a.m. I went to a testing facility immediately and got it taken care of. And the positive for alcohol from the UA, yes, I did not have the children the night before. I did drink. Not gonna lie about that at all. I didn't have the children. I was at a friend's house and we were celebrating, and I was completely responsible about it. And there's no drinking problem. And prior to that, I hadn't had a drink in a couple weeks. Mr. Crocker has an extensive history with drug and alcohol, along with lying to law enforcement. And the event on the 28th, I never took the children from Mr. Crocker. I went to pick them up as agreed upon on the 13th with Mr. Crocker. When I picked them up, that's when he let me know he had relapsed for the third time, and I felt the children were in danger. So I kept them from the 13th to the 28th, and I allowed him to come spend time with them while I was working on filing paperwork and looking for an attorney. And he walked into my house without knocking and picked up our son and ran to his truck and then drove at 80 miles per hour with me in the bed and our son unbuckled in the truck until law enforcement had to pull him out at gunpoint. And when he was talking to them, he told them he was going to pull over and never did so until two officers pulled up behind him with lights and pulled him out at gunpoint.
Well, I'm going to
Mr. Crocker, Mr. Ignacio says that Mr.
Stop.
Crocker doesn't.
Ms. Acevedo, stop. I don't want to retry this case. I get it that it's there. I get it that it's pending. I just move on from there.
Mr. Crocker does have somebody who wrote a declaration for him, Dakota Myers. She is a danger to children. CPS has removed her own children from her care. Mr. Crocker and I were watching her daughter, and she brought us a baby, black and blue, and Mr. Crocker and I reported her and got her child removed from her care because of the danger that she put the child in. And I've submitted copies of her parenting plan that the court had issued her. She actively abuses children, and now Mr. Crocker has her in the home and is in a relationship with her. And as far as my relationship, I knew of Hayden Hess for 2 to 3 weeks in February, and then I realized that his last name was not the last name he had told me. Initially, he told me a different last name. When I learned of his history and his sexual offenses, I no longer involved myself with him. And Mr. Hess has been in prison since March 30th of last year, and I have had zero contact. Mr. Crocker refuses to acknowledge my current partner that I have been with for 10 months. Mr. Crocker has met him. Him and I went to Crocker's house on the 4th of July to do fireworks with Sam, and Jordan has also dropped the children off to Mr. Crocker. They want to continue to accuse me of being in a relationship with a sex offender. Said sex offender has been in jail for almost a year. There was never a relationship. It was a brief amount of time where we hung out. The children were never left alone with him and barely even around him during this time. I have no problem with UAs. I will take a UA every day, absolutely. I did initially do an entire evaluation when the court first asked for a UA and a hair follicle the first time. I went and got a UA and a full evaluation without the court asking, just to make sure that if the court needed an evaluation for me, I already had it. I have no problem taking another, but I do feel that every time we try to come to court to come to resolution, Mr. Anagnostou and Mr. Crocker seem to have new matters. Now they are accusing me of burning my daughter with cigarettes on her back, but the cigarette marks in question are birthmarks she's had her entire life. And if Mr. Crocker was unaware of those big red blood birthmarks from birth, how aware is he of our child's well-being in general? She's almost 2. And he's just now seeing these big red marks that are not even the size of a cigarette and accusing me of burning her. I spoke with CPS. They came to my house yesterday, and the bruises on the children are bruises on their knees from falling down. Our children are very wild. The CPS workers seen that. Twyla has seen that. They're regular standard toddler bumps and bruises. There is no abuse with the children. And Mr. Crocker also took the children down to Vancouver outside of their normal hospital and accused me of sexually assaulting our daughter as well. I feel he's grasping at straws and trying to drag out this case in an attempt to control the entire situation with me and the children. He is a complete danger.
I want to stop you for just a minute. I want it understood. I do not have that motion in front of me. And that's an ex-parte motion, which I don't know what Mr. Anagnostou did with it. I don't have it in front of me. I have not read everything in that packet, so I just want everybody to understand that, as far as what we're doing here at this moment. So go ahead.
I feel that Mr. Crocker and Mr. Anagnostou are grasping at straws, and every time we come to court, they seem to have new information between the abuse and that they're claiming. Why was this abuse that he claims he's seeing now never mentioned to Twyla? Why was it never brought up before that he believed I was abusing the children? That didn't get brought up until he involved himself with Dakota Myers. And I believe she's guiding him and coaching him into what to say to assist him in getting the children. Because none of these things are factual. I'm being accused of so many awful things. And they're not true. And it's causing stress on myself and the children. They come to my house and they eat for 2 days straight like they haven't eaten, and they're drinking water like they're so dehydrated. And Callie comes back and her hair is nasty and matted up, and they smell, and their baby blankets smell, and I'm the only one caring for them.
Okay, stop. I don't believe that's any part of the record that I've seen.
Right.
All right.
Your Honor, can I comment, please?
Yes.
So Mr. Crocker has had 2 recent negative hair follicle tests. However, neither one of them has included testing for fentanyl, which is his admitted drug of choice that he had relapsed on. And one other thing is the physical injuries only came up on February 29th. After my report was filed on February 7th, I had heard nothing of any physical injuries until that point.
Okay. Anything further?
No.
All right.
Well, Your Honor, brief response that my client is not in a relationship with Dakota Myers. Dakota Myers is my client, has a roommate. The roommate is Dakota Myers' grandmother. And so he's not in a relationship with her. If the court wants a test with regards to fentanyl, I guess that's a special request. My client will submit to any testing. He doesn't have a problem with that. The issue is last week, the court ordered them to do yet, another hair follicle and UAs, and Miss Acevedo's is positive for marijuana and alcohol. And that's what he's been pointing out to the court repeatedly, that she has a untreated drug and alcohol issue. Now, she says that she's had a full evaluation. If she has, it's not part of the record here, and nor was there any request from my client to give input to it. So we again asked that the court order her to have a full evaluation with input from my client, and that at this time the residential arrangements stay the same going forward, and that we set this for trial and have witnesses come in and testify about the best interest of these children.
Let me ask you this, Mr. Anagnostou. Has your client had a full evaluation with input from Ms. Acevedo?
I don't believe so. He would. He doesn't have an issue.
So here's what I'm going to do. I've reviewed the files and record, including the drug test provided by Mr. Crocker, and I've not seen the actual Ms. Acevedo at this point, but I've heard what it was positive for. Ms. Acevedo, you should file that and do it under seal. There's a special document to put on it, so it's not open to the public.
I filed that.
The UA or the evaluation. I did file both of my UAs that were requested last week with the courts yesterday, cover letter included. I filed it right before the cutoff time.
Okay.
And then Mr. Ignostou also emailed you a copy, because I did email his legal assistant copies of my UA when I received them.
Okay. All right.
And original eval should be, it was submitted with my original UA. It should be with it.
Okay. So here's so based on the information, the court sees the similarity to what the guideline said, which is there's finger pointing both directions. And that said, not to minimize what Ms. Corey has said, but a guideline recommendation and report is that recommendation. And so at this point, what I'm going to do is leave things as they are currently, and the matter needs to get set for trial. And then the judge or judicial officer can weigh the credibility and make a determination. Meanwhile, I want both parties to have a substance abuse evaluation with input from the other party. And for Ms. Corey, you may be able to tell me this. I'm trying to recall. I think the test that I saw from Mr. Crocker was a 5-point test. Does that sound right?
The 5-panel hair follicle test.
Right.
Yes.
So yeah, they need a 7-panel, correct?
17, actually, and specifically make sure that fentanyl is included in that.
So I'm sorry, the guardian ad litem said 17. Is that?
Yeah, I actually spoke with Performance Occupational Health Services yesterday to kind of clarify this for myself. And they did tell me the 5-panel does not cover fentanyl. It's not included unless you specifically ask for it. And the one that covers everything, including fentanyl, is a 17-panel.
17. Any idea what the cost is?
I don't know.
Okay. Well.
Okay, so I want each party to have the 17-panel hair follicle test. So no dyeing the hair, no cutting the hair until that gets done. And hold on, and make sure that fentanyl is included in that test.
Your Honor, both of the hair follicle tests I have submitted did in fact test for fentanyl. It's costing me about $450 when I have to take these tests. And due to Mr. Crocker taking his 5-panel test the first time, I had to actually cover the cost of his second test to take the proper 17-panel the second time he got his hair follicle done. And then he returned to the 5-panel on this third one.
Okay. I don't, Ms. Acevedo, I'm ruling right now. Okay, I get it. You may not want to do it, but I want a current one 17 panel, each of you with fentanyl. And the
Can
matter needs to get set for trial.
Ignacio and Mr. Crocker cover the cost of this round of tests, as I have already paid for one of Mr. Crocker's and I don't have the funds. I'm $1,500 in debt over the hair follicle tests Crocker and I have taken alone, and I don't have that money.
I don't know why you paid for his. I don't know what was behind that, but at this point, no, I'm not. I'm asking that you each get it done. I want it done, and I want the matter set for trial.
Okay, I believe we have a trial date set tomorrow at 1 p.m.
That'd be a trial setting date.
Correct.
Okay.
Yeah. So they'll tell you when your trial is going to be set. Okay. So, Mr. Anagnostou, are you going to prepare an order?
I will prepare an order, Your Honor.
Okay.
Both parties are to get a 17 panel test, and both parties are to have a substance abuse evaluation with input from the other.
And the 17 needs to include fentanyl.
Right. 17, including fentanyl. I keep assuming that it does, but you're right. I should put that in the order.
Yeah.
Okay.
All right. So I'll go ahead and set this on for presentation in 2 weeks.
Very good, Your Honor.
The email I sent to Twyla, I don't have the exact date, but I told her about the stuff with the kids before her report went out, not after.
The Stevens v. Meter matter. And for the record, we have Ms. Meter here in the courtroom. All right, this matter comes on. I received an email back on Friday, March 1 from Ms. Fellows. I know the matter, I believe, was on last week and was set over a week. So with that, counsel, did you receive the email?
I did.
Okay.
Did as well.
All right. And Ms. Fellows, do we still have you present?
Yes, Your Honor.
Okay. All right. So counsel, I'll go ahead and if you want to go ahead and address what Ms. Fellows has stated.
Yes, Your Honor. And then my client also gave you a declaration back on February 23rd, updating you kind of what happened, which largely mirrors Ms. Fellows' most recent information. I guess the really only fair way to say this is things have gone from terribly bad to extremely worse, not only for Mr. Stevens, but for these kids as well. Last time we were here, you had ordered that you wanted a little bit more information on things, and it modified, again, that was pursuant to a court set review hearing, what we were doing by way of visitation for Nathan, the 17-and-a-half-year-old child. You expanded that visitation a little bit, gave Mr. Stevens every other weekend from Friday evening through Saturday morning. That plan never got off the ground, as shortly after the hearing, I believe it was on the 13th, Mr. Stevens' current wife, Tori, filed for a order of protection on a restraining order, and included some allegations of domestic violence. Mr. Stevens apparently decided on the heels of that to skip town and move to California, where best information available to us through the GAL and my client is that he's still there. There's been no communications between Mr. Stevens and the children that we are aware of, although we do suspect strongly that he's still trying to communicate with Nathan in some form electronically. So that's what we have on that side. I know Ms. Fellows has spoken with Mrs. Stevens, the existing current wife, at length about the allegations. Again, has been prominent throughout this. Domestic violence is kind of at the root of that, as well as the emotional health of Mr. Stevens. Given that latest incident, again, knowing that you're under the spotlight, that's certainly concerning. We do renew our request for a full psychological evaluation with a parental risk component. We also request that there be a domestic violence evaluation with conducted through Olivia Lovely in the local area. Again, would ask for input from the GAL and my client. I think that's appropriate. To remind the court, my client has a lifetime restraining order against Mr. Stevens that was entered through the divorce. in Clark County back in, I recall, 2014. So those issues, unfortunately, have not been put to bed. We did provide you with a copy of the information from Clark County, the most recent information filed on behalf of Tori Stevens, which again shows various and extremely unusual acts of control, domestic violence, not only to her, but her adult children as well, which certainly gives rise for additional concern. Would suggest, and again, this is contained in my client's declaration, was part of the discussion pertaining to the last GAL report related to the Our Family Wizard. That is yet to be done. So there is no communication. Mr. Stevens has apparently just kind of brushed his hands of anything related to this, including the Our Family Wizard. There was communication at the last hearing in which argument was made that, well, he was having a hard time locking on and doing these different things. And in our estimation, the reality is just he simply doesn't want to do that. So again, further issue related to the practicalities and prior orders that were entered by Your Honor and before. We, as another practical concern, not necessarily related to this, but in a roundabout way, certainly is to the well-being of the kids. There's been some communication between Ms. Stevens, who we understand owns the home, continues to reside in the same home that the boys were at one point having visitation in. Several of Nathan's belongings are still there. She has indicated she would like those out. We are asking for a specific order that the court allow the communication between Nathan and Ms. Stevens so that they can arrange a time for him to get the various items he has there. My client has limited information of that, and she's obviously never been inside that home or knows. But what we do believe is that there's his clothes, video game console, virtual reality goggles. We understand he has some silver coins there, as well as some other monetary things that we would like him to get. Liam, again, has things at his father's house. It's our suggestion that Nathan just be allowed to coordinate a time with Tori so that he can go down there and pick up not only his belongings, but those of his brother as well. There's been, and again, I think the record is complete with this. There's been issues in the past when Mr. Stevens would, allegedly agree to something only to say, well, that was never the agreement, you're stealing from me. And we would like to avoid that. That was done primarily through the divorce action. But we think our proposed verbiage makes sense, gets the boys their things and gets that out from Ms. Stevens to control and possession, who is at this point just a third party to this case. And that probably makes the most amount of sense. Asking for a new parenting plan to be entered. And we haven't heard anything from Mr. Stevens. I didn't get any kind of a responsive declaration from him. Didn't get any pleadings, didn't get anything outside of my communications with Mr. Roberts, which there's been several of those since we were last in front of court. But we're asking, and we certainly think that additional 191 factors are appropriate given the circumstances. We do think the domestic violence finding, the use of conflict, neglect, and again, this is related directly to Liam's ARFID treatment issues. It sounds like those information continues to come through the GAO that is very concerning. We think that a neglect specifically related to Liam's medical related issues is appropriate. Also, and I think it dovetails that same argument, mental and physical abuse of the child. Again, that goes back all the way to the contract that Mr. Stevens decided to have the children, because Nathan was signed on as a witness to that. Signed that, I think, is about as abusive as you can get to a child's emotional and mental well-being. And we do believe that finding is appropriate, as well as clear emotional issues. I think you add those up and it puts us in a spot where additional 191 factors are appropriate. And I think a strong case could even be made now for an abandonment 191 factor, even though it's only been about a month and a half since Mr. Stevens left. The last issue for resolution today is related to attorney's fees and costs. This was one that you wanted information from my client as far as what she's paid in my fees and services to this point. My client details for you that she paid a $6,000 retainer to my office back in the fall when we commenced this. That has largely been expired. I've lost track of the amount of hearings we've had, the amount of pleadings that have gone back and forth, the involvement with the GAO. This has been one from a practitioner standpoint has been extremely time sensitive. This has been one that's been extremely detailed, and we have done a lot of work on this case since the fall, only to have the bottom fall out again due to Mr. Stevens' ongoing efforts to basically sabotage himself and his relationship with these kids. We are asking for the full amount of the retainer be ordered, the $6,000. I can say as an officer of the court, we're now in the middle of March. There's been additional fees. The $6,000 requested to contemplate that. I believe my client probably owes me upwards of another $1,500 to $2,000, not including my time preparing for today and appearing today. So we're asking for the full award of fees be issued. I can certainly send printouts to Mr. Roberts to confirm and verify my time with the court. So request, happy to do that. Also asking for contributions towards Ms. Fellow's time. My client has paid her $100 to date, goes for an additional $800. And again, this is one where I certainly appreciate the work that Ms. Fellows has done. So I know this has been labor intensive for her as well. And again, I think the basis of why we're here, the basis of why now we're on the verge of basically not knowing where we proceed from here, given him leaving to California unannounced, puts us in a position where the request for fees is certainly appropriate. We're asking for that relief. Our agree to Ms. Fellows' recommendation related to the full psychological evaluation be done with a state certified preparer. I think that certainly makes sense. And we'll see where it goes. I have reached out to Mr. Roberts. He typically is, and I typically communicate very well. This has been no exception, even though these are extreme circumstances. We did send out proposed final resolution. I don't know where we're at on that, or if that's a possibility at this moment. But for now, sticking to the schedule that has been put in effect, I think makes sense. And that is entering a temporary parenting plan, again, modified to eliminate contact between Mr. Stevens and both children is appropriate with the 191 factors I previously addressed. I think that makes sense for where we're at in this moment. And that's what we're requesting.
Mr. Roberts, anything?
Yes, Your Honor. There's quite a few things to address. So I will try to address all of them. My client is in California. There is a pending domestic violence protection order in Clark County. It is contested. It has not been resolved. My client has not had an opportunity to respond to that. As a result, I'll ask the court to maintain the factors that it previously found. I think those, I'm not going to relitigate that issue, but there's this outstanding issue with his ex-wife. Well, excuse me, his current wife, who may be his ex-wife. They owned a business together, or technically they still do. Fleeing to California is a spin I don't agree with. He was kicked out of his home and had nowhere else to go. In addition, his father's very ill. His father just had open heart surgery recently. I don't know if it was 2 days ago or last week, but my client informs me that just recently happened. And he did inform me previously when he went to California that, number one, he has nowhere to stay because he was kicked out of his home. And number two, he has an ailing family in California that he was considering going to stay with anyways. So I think an abandonment finding is extremely premature. We're in the middle of a temporary domestic violence protection order without a resolution to it. We have enough information in this case to satisfy the court's concerns about protecting the children, consistent with prior rulings and information that you have made. With respect to the technical issues of it, obviously visitation can't happen since he's in California.
But object to anything that's not contained in the pleadings. I certainly understand Mr. Roberts' position. It's difficult from his practitioner standpoint, but this is all new information to me.
Mr. Roberts, please restrict it to anything that's been submitted.
I understand, Your Honor. There's just been emergent issues going on. What I can say is, with respect to visitation, I mean, Mr. Zandy's asking for an abandonment finding after 1 month of a domestic violence order, a DVPO being temporary and being in effect. My client hasn't seen Liam for several months due to issues in this case, but he's been trying to do so. He's in the process of getting back on his feet. I think the court can reach that conclusion based on what is in the record. We're in an emergent temporary situation that has not been resolved. Because he's in California, and I think that's clear to everyone, he can't have visitation with Nate, but he is willing to undergo an evaluation. He'd ask that the domestic violence be carved out because there is an ongoing DVPO. The court doesn't need that information for to make rulings and protect the children. And it's not an issue that's been resolved, and he hasn't had time to respond to that in that case, and responding to something in this case would be problematic while he's litigating that case in itself. And I think the court understands that. He would ask for some phone conduct contact with Nathan. Mr. Zandy indicates he suspects there's some electronic contact attempts. That's not in the pleadings, and that's not supported by any evidence whatsoever other than rampant speculation at this point. My client does want to contact Nate, but he has not done anything to my knowledge or in the record to attempt to do so. But I think that some contact with him is appropriate, since nothing new with respect to him and Nate has happened in a detrimental fashion. And the court did order visitation with him previously because of the circumstances. He can't have in-person visitation, so some phone, video, text, email contact is something that he would ask for. With respect to attorney's fees and fees, my client owned a business with his potentially ex-to-be wife. There's been no divorce file, but he doesn't have the money to pay it. He frankly owes my office money. Has not been able to pay it. I've recently been informed, I didn't have time to bring it to your court's attention, but we can establish this, that he's been locked out of the all accounts from his wife. So he has no way to pay me. He has no way to pay Mr. Zandy or anyone else. And he's struggling. It's just not a possibility to make these payments and move forward. So he is willing to submit to an evaluation pursuant to the findings the court has made previously. He does want to do what it takes to jump over the hurdles ahead of him to address the concerns the the court has raised and the court has found, to rekindle time in contact with both children. But the circumstances are such that it's very difficult right now. He has indicated to me that our family wizard is having some technical issues that he has calls into them. He intends to make this happen as soon as possible. So I agree, because of the court's prior rulings, with much of what Mr. Zandy has provided and requested. But the domestic violence, I believe it's premature. The abandonment, I don't think there's a basis for that. And I'm asking the court for some way to carve out, long distance contact until he can be, unless he can be local again, because it's just an impossibility at the moment. He's willing to start treatment. It's going to be an issue for him to get the funds, because right now he just doesn't have access to anything and he's rebuilding. But he simply can't afford what's being asked for. Litigation is expensive. Litigation happens, and the financial circumstances are such that even if the court was to find that there was grounds to award some fees, he simply doesn't have the ability to pay.
Mr. Sandy?
Yeah, again, that's difficult to reply. This is information that I'm receiving for the first time. Again, it's just not before the court, and certainly is news to me. In the well-being of these kids is paramount. We have more questions than answers with Mr. Stevens. We have very little information on what's happening right now, other than it's more chaos, it's more mayhem, and it's more dysfunction. And that's basically the only way you could put that. It's an individual who over time has earned a significant amount of income, who has resources. I have very little sympathy when he said, well, I don't have any money now because of my own choices to act in ways that are, again, ludicrous and outside of reason, whether that's domestic violence or otherwise. He's put himself in this position, and he continues to dig a hole. And that's the reality, not only for my client, not to deal with the fallout of that, but more importantly, these two kids who have been exposed to this every step of the way. So I think the relief is appropriate. I think it's certainly reasonable given the circumstances. And as I've said from the onset of this case, a strong message needs to be sent to Mr. Stevens that his conduct is just inappropriate. And he just fails to acknowledge that or see that. And therefore the position that we're in now.
Your Honor,
yes. Yeah. Go ahead.
Your Honor, I would like to bring it to the court's attention that it looks like the father is online. I see somebody as Mark Anthony, and I believe that is the father. So that should be brought to the court's attention that he is here. So my email, my recommendations, they stand. My concern is that the dad left town. This happened with his wife. He got kicked out, the DV allegations, the restraining order, and he left town. Nobody knew where he was. His son, Nathan, he was supposed to have his first overnight visitation the weekend approaching when he left town, apparently. Nobody knew. And so Nathan was left not knowing where his dad was, worried about his dad, and things like that. So at this point in time, I can understand that he would like to have contact with Nathan, but I am not recommending it whatsoever. I have concerns about any contact that the father would have at this point in time with either child, young adult, until he does the psychological evaluation with the parental risk. There's a lot of issues that are going on with the dad, and he needs to go through that evaluation. I did start, like in my email, I did start doing, talking to the doctors at Cartini. There were concerns. I did not follow up with the other doctor because this whole situation with the restraining order and dad leaving town. So at this point in time, I don't feel like this is the best thing for Nathan, even though he's 17 and a half. I just don't think it's the right thing. And I really think that the dad really needs to do this evaluation and basically deal with some of the things that he's done and put his sons through. So the psychological evaluation with the parental risk, with collateral contact with myself and the mother. And I understand about the DV evaluation given the restraining order, but I do think that is an important part, and no contact.
Okay.
So, Your Honor, if I just may, at least in the point of the contact, I mean, when he was kicked out of his home, I understand Ms. Fellow's position, but there's a pending domestic violence protection order. It's not there has not been a finding in that case whether it should be permanent or not. But when he was kicked out of his home, he's not allowed to contact the children directly. So the fact that he hasn't contacted Nate is something he was unable to do anyways. So he was kicked out of a home, didn't have anywhere to go. He was effectively homeless in this area. And so he went to where family was, where he had a roof to house him. You can say whatever you want about the other circumstances, but the fact that he didn't notify Nate, there was no way for him to do so, pursuant to the court orders, lest he violate the provisions. We asked for contact at the last hearing to where he could have email, text, phone contact, or whatever the court thought was appropriate, and the court said no contact other than the visitation. If he had that ability, he could have texted him and saying, "Hey, this is what's going on," but he had no way to contact him. I think that needs to be clear for the record.
All right. So based on the files and record, I had and have had significant concerns in regard to the father from the point of the starting of this case. And the court wanted to see what the father would do and could do. And instead of seeing improvement, instead we have more things that I understand at this point. Full hearing has not occurred, but pretty serious allegations that, again, are very concerning in regard to the children, the impact, the effect on these children, and what needs to occur in regard to the best interest of those children. That because of that, the court does find and does adopt the new 191 findings as proposed by Mr. Sandy, except the abandonment. I'm not convinced on the abandonment because it's not a long amount of time. Is it, close? Yes, potentially. But definitely the other findings are appropriate. And based on that, the court does not find it's in the best interest at all of these children to have contact with the father at this time. With that said, the court does order a full psychological evaluation and with a parental risk component by a PhD level practitioner, as well as a domestic violence evaluation with an input for both of these should be coming from the mother and the guardian ad litem. And then obviously the other decision-making would be solely with the mother, dispute resolution, the court. So at this point, that's what we will do in regard to the parenting plan. In regard to attorney's fees, what I have seen and what I've heard over and over again is the major issues that we've had in this case relate to that of the father. And because of that, we've been in court, I don't know how many times now, at a great expense to the mother. And so the court is going to order $7,500 in attorney's fees that will be paid. Not quite sure how that should be done, but paid within 90 days to Mr. Sandy's office. And that in regard to the guardian ad litem fees, the court does order the father to pay an additional $1,500 to the guardian ad litem. I don't have anything to look at, so I don't know what the costs are at this point, but would consider additional amounts later. But at least for now, again, to be paid within 90 days. The other thing that I wanted to add that did not get addressed had to do with Nathan picking up the belongings of the boys. Did you have a date or time or something, Mr. Zandy, or is that to be addressed with?
No, and I think probably the easiest way to do it is just have Nathan arrange something with his stepmother, and if they can't arrange something, then you know, I can put something together for a specific date. I just don't want to bind a third party with our order, which might not have the effect it otherwise would. And I'm confident that Nathan can do that with his stepmom. She's been since February 13th, pretty cooperative with that. So, and the GAL has talked to Tori Stevens as well. So maybe that's another avenue that we could employ. I don't think we need to necessarily set anything in an order unless it's vague and broad and just says within the next month, Nathan can pick up his things from stepmothers by agreement of everyone.
So, Mr. Zandy, your client is wanting to address the court. She's here in the courtroom about this issue. I don't know if you're okay with that or not.
Given the circumstances, she has more information than I do. I have no problem. Melissa, if you give limited information to that on what a day you would prefer.
Okay. Tori Stevens contacted me via email, and we set a time for Friday at, I don't know, in the afternoon for an exchange of the boys' items. I sent her a list and she said she would bring them to Woodland where we used to do exchange. Is that okay?
Okay. So what, I don't know if you could hear that, but she said that she's already talked to the stepmother, it sounds like. I'm assuming that's who that is. And they has an exchange of items in Woodland on Friday at what time?
I think it's at 6.
At a time that they've agreed upon anyhow.
The only thing in question was the boys had saved up money and their dad put him in accounts. And she said, I can't do anything with that.
Yeah, I can't help you with that one.
Yeah.
Okay. So.
Sounds like it's resolved itself. I'm good with all that.
Okay.
Your Honor, could there be a little bit more language added to the evaluations?
ahead.
As in my email, I had requested, excuse me, that these evaluations should be done by a Washington State certified licensed court approved providers.
Yeah, I apologize. I didn't keep reading here. I agree. These evaluations should be done by a Washington State certified licensed court approved provider.
Thank you, Your Honor.
Your Honor, when you have a chance, can I chime in briefly?
I'm sorry?
Can I say something when you have a moment?
Go ahead.
With respect to, I've had some cross-state issues before. I don't know if there's going to be, I've had issues previously with a client in out-of-state. California was that example, but it doesn't really matter, where it was really challenging to find a Washington provider because they have to be duly licensed. They will say, if they're in California, my license won't, I'm not comfortable evaluating them. So I'm wondering if we can put some backup language in, or if Mr. Zandy would consent to something different, to where the evaluation can still be comprehensive, but there's issues with Washington providers where they say, well, if you're in California, my license doesn't cover you and I'm not touching it. And then we have to come back to court because there is an issue with the provider being even willing to touch the case. I also wanted to ask if the court would allow perhaps 180 days for the fees. I think the only way he's going to have access to any money whatsoever is if he files a divorce and tries to get some temporary orders with respect to finances. Right now, he just doesn't have it. I know I've told you that already. I'm not trying to relitigate. I'm just speaking to the practicality of having that money, and it might take some litigation to get it to get something available.
Your Honor,
go ahead.
Pardon me. I know the matter that Mr. Roberts is talking about. However, Washington State has very specific RCWs regarding DV evaluations and treatment. And so it needs to be done by a Washington State provider. That's a very important part. I understand that it may be a little bit difficult for him to do an evaluation, but it's not certain whether or not he's going to stay down in California or come back up here. But I do think, given the seriousness of the allegations and the restraining order, the history of this case, I don't want to minimize that. And I think having the DV evaluation specified that it has to be Washington State certified, because the RCWs for a DV evaluation are very specific.
Mr. Sandy, anything?
Yeah, I don't disagree at all with Ms. Fellow's comments on that. I think Washington, again, this is where the history is. This is where the kids are. And my understanding from the comments from Mr. Roberts earlier, where he may or may not be in California for an extended period of time, because again, we just don't know. It needs to be done. We need it done locally as opposed to a different state. I think the Washington recommendation makes sense, and we would ask that Ms. Fellow's recommendation be upheld in that sense. As it pertains to the attorney's fees, again, whether it's 90 days or 180 days, this is something that has been brought upon by Mr. Stevens in his own action. Instead of getting out of the hole he's dug himself, now he chooses to keep digging. My client needs the financial help. If the court's inclined to go 90 days, I think that's appropriate. If it's 120 days, again, is what it is. But I think 180 days is, frankly, far too long. So I'll leave it to the court's discretion related to that issue.
So in regard to the timing, I'll extend it to 120, but I'm not going to put it at 180. In regard to Washington State, I agree there are very specific requirements. The only language that I would go ahead and authorize to be added is unless otherwise agreed upon between the parties and the guardian ad litem.
And a presentation in 2 weeks.
Correct.
Yeah. Very well. Thank you.
Thank you.
Your Honor.
Thank you, Your Honor.
That concludes this docket.